Hi, and welcome to The Leader's Edge. Today, our topic is the CEO of your legacy. The awareness question for you then is: are you the CEO of your legacy? Are you aware of what this means for you? And are you taking the steps to proactively plan for what you leave behind for your loved ones or causes that you care about? Georgia, let's introduce our guest.
Thank you so much, Emily. Good morning. Welcome, everyone. Aliyah, welcome. It's such
Thank
a pleasure to
you.
have you on the show this morning. Folks, we have Aliyah Hamel-Smith with us, and she wears many hats. I know two hats that are very special to her: wife and mother. So, having said that, she also has some other hats that she wears. She's an attorney at law, and she is the managing director of Executrust, and that's a future planning company. Elia also has experience serving on boards, and she has been in banking, she has been in insurance and employee benefits. So, Elia is a perfect person to talk to us about CEOs owning their legacy. Elia, we know that CEOs and leaders, managers take a lot of time to talk about their own businesses and plan and strategize for their businesses. But unfortunately, they don't spend enough time on their own business, themselves, and their legacy. Talk to us about what you think people need to do, people in those positions need to do to secure their legacy.
Great. Thank you so much, Georgia. Emily, thank you all for inviting me onto such a interesting platform to cover such an important topic. And I laughed when I smiled when I read it because we know it, especially from the banking sector. We spend so much time stress testing and liquidity ratio measurement, capital adequacy for the sustainability of our companies. But what about the sustainability of our lives?
Mm.
I have had an unfortunate circumstance where one of my top clients, he has a firm of about 35 employees, and within the space of 2 to 3 years, four of them, all male employees, passed away. They were all in their early 50s. So it was devastating to the company, obviously. And as a result, and of course, he was the CEO of the company, and he saw the stress and anguish it caused the widows of these four deceased men. So he offered to all of his staff to pay for them to do their wills so that their beneficiaries and loved ones they left behind wouldn't be in such a quagmire. Do you know only three of them took him up on the offer? Three.
No, I don't believe that, Elia.
Three for free. He was willing to pay, and he said, "You didn't have to go by Aliyah. Wherever you feel comfortable, where you want to do your will, I will pay for it." Only three took him up.
Yeah, that
Wow.
says a lot about how we maybe locally look at this idea of legacy of wills. Maybe I don't know if we don't trust the wills, whatever. I mean, I think whenever you get offer anything free to a Trinidadian, we just run and get it, right? It could be anything. So it's interesting that only three out of how many you said?
35? 35.
45. Wow,
Wow,
wow.
that
So
ratio, that ratio is stark.
yes.
Hmm.
So for the people who are on the fence and the people who didn't take this up, let us understand from you, Aliyah. What really are we missing out, and what stresses are we causing our loved ones when we do not put things in place?
Great. So let's start there. The without having and I would call it an estate plan, right? Because there are many instruments that comprise an estate plan. I mean, in a nutshell, there are powers of attorneys, wills, trusts, succession plan. But without having one, you don't know what you need, and relying on the internet and relying on things that you read, especially on social media, you're always skewed because 95% of those are US based and US centric, which may not necessarily apply here. So let's start with some startling facts. By law in Trinidad and Tobago, if you die without a will, the laws of the country determine who inherits what you've left with. So if at the point of your death you have a spouse or someone who meets the threshold of a cohabitant, meaning they've lived with you for more than 5 years and have a utility bill, or 3 years and you have a child together, they are entitled to 50% of everything you own. And all of your children, no matter which child, mother, parent they're from, all of your children are entitled to the other 50% in equal shares.
Hmm.
All right. If you don't have
Well,
spouse, Exactly. So that in itself is fraught with confusion and complications because children come out of the woodworks. Children who may not have taken care of you in your old age, or you don't want to inherit anything, are legally entitled.
Yes.
If you had a will, you can absolutely name who you want to leave these assets to, and there's no confusion. There's no people making petitions to the court. Well, I am a child. This is my paternity test. This is my DNA, and claiming their legal stake because legally they are entitled. They don't even have to have the father's last name, but you open up the woodworks for all of these people now.
Because you didn't have a will.
You're right. Yes, yes. And it makes grieving so much harder.
Gosh.
Absolutely. You know, there are other things people don't realize. Well, it's the same cohabitants, and we have a lot of those in Trinidad. But to establish your status as a cohabitant, you have to make an application to the court within 30 days of the person's death. Is that what you're thinking about while you're grieving 30 days after they died? Yeah. So
you're right. If you were the rightful, you were expecting to receive something, or you were the rightful person, you also can lose that right.
Exactly. Or you have to make even more applications, and which is cost, right? This is hiring attorneys to go to court on your behalf. Whereas
which you may or may not have the means to do.
Exactly. If the deceased had just done a will naming you as the beneficiary of the house or the car, that you just probate that will and you're entitled to it. You don't have to prove that you're a cohabitant. And I'll tell you where that gets even more complicated. And again, a lot of times in Trinidad, you've left your spouse, but for whatever reasons, you all are not going through the divorce process, but you're now living with someone else. And for years, you're living with that person. So they do qualify as the cohabitant. On your death, your spouse is the one, your legal spouse who you never divorced is the one that's entitled.
Yeah, because that person is still legal.
Yes.
Yeah. And you didn't have an opportunity to provide for the way you would have liked to.
If you had done a will, you could have exactly provided for the cohabitant. Yes.
Yeah. Aliyah, one of the challenges we see is that people think that when you talk about a smooth transition of wealth, it's only the money you have in the bank. But they're not thinking about assets and maybe family business interests. Talk to us about that.
Absolutely. So a lot of times when people think of succession planning, they think of it as we're grooming the next CEO, and do I send him for professional training? Does he get a formal coach? Maybe he needs to meet certain academic qualifications or licenses. That is, yes, one aspect of succession planning for the business, because you need someone to continue operating it. But those people are operators and maybe even directors of the company. But then there's the whole other, which I guess it's probably more the legal side, which is where your shareholders of your company come in. So the shareholders choose the directors, but the directors are the one that run the business. When it's time when the matriarch or the patriarch passes, it's their shares in the business. What is the succession planning for those? Is it that it's going to go to their children? Their children may not even be living in Trinidad and interested in running the business, but the CEO and the finance person and the accountant who's been there with the matriarch and patriarch from day one, what happens to them? They're working for who now? They're working for someone who's inherited shares in a business they know nothing about. So, when you go to your seasoned estate planning consultant to talk about your estate, you're absolutely right, Georgia. These are all the facets of your estate that must be good, right?
Yeah, that's such an important point.
Yeah, because there are things and tools you can implement from now while you're still alive. Things like your shareholder agreement, your buy-sell agreement, things that you can put in place to determine how your ownership of the business, separate and apart from the running and the day-to-day management of the business, is to coexist.
Right.
There's so many risks. Go ahead, Em. So many risks.
Yes, exactly. I was saying the same thing. So many things to think about.
And guess what? We haven't even spoken about all the family disputes that we've heard of.
Yeah.
Aliyah, I'm sure you've heard your fair share.
Girl, I can write a book or a Lifetime movie.
Yes.
A Lifetime movie, unfortunately.
The family disputes and the tax implications. Yeah, all the family disputes, the tax implications, the loss of control, all of those are issues.
Yeah.
So let me address tax implications. We don't really have. I mean, Trinidad is a very good jurisdiction from a tax perspective. Even though when we see the PAY coming out of our salary every month, we may not agree. We may not agree with me, but from estate and death duties and succession planning taxes and duties, we actually have none. So when you pass, your assets can be transferred onto your next of kin free of tax. And that's, in fact, one of the beauties of doing a will. I mean, I know a will has a bad name in Trinidad because people have waited years and years to get probate. I would tell you my take on it is so twofold. One is that the probate registry has improved tremendously since COVID. We get
good.
grants now 5 to 6 months from the date of that. In fact, the last grant I got when I called the widow to tell her, she's like, "But it hasn't even been a year. We haven't had the prayers of my husband. I have no closure. I'm not ready yet." I'm like, "So you're angry with me because I got the grant to probate too fast?"
Oh my goodness, because she didn't expect it.
Exactly.
So 5 6 months, that's an improvement.
That's a huge
improvement. Yeah.
Wait 12 years. I know
I
people
remember
Oh
that.
my
And I was
goodness.
wondering, is it because just administratively there were issues, or is it that they did not have wills and they caused things to go so, take so long? I mean, like, what caused it to be so long?
I think it's all not having wills. It does take longer. There are lots more thresholds you have to pass because if you don't have a will, it's your spouse who's the person to apply. If the spouse is divorced or deceased, you have to attach the documents. But then all of your children are all equally entitled to apply. So you have to agree on one, I would say one or two. The law provides up to four of you to apply simultaneously. But the ones that are not applying, you have to get their consent. And if they live overseas, you have to get their written consent. There are ones who don't want to consent, but they don't want to apply either. So it's a lot more.
So the process is a lot more protracted when
Yes.
you do not have a
Exactly.
document called a will.
And all of that is still to make the application to the court. When it gets to the court, then it's more years and months for it to be reviewed by the probate registry. And of course, if the person who's doing it is not skilled or experienced in estate planning applications, they may miss out things and not phrase things properly. And then the registrar sends it back. They have to do supplemental affidavits. The person to swear the affidavit may be dead by then. So it takes it's an entire process. And then when you file the supplemental, it goes to the bottom of the probate registrar's desk. So you wait a few years, months before it comes to the top again.
Is that why people didn't bother?
I think so. I think to a large extent. But I keep going back. I guess I'm a huge advocate of wills because I see how you can control your future. With the will, you specify exactly who your executor is. So there's nobody having to clear off all the other siblings to apply. You've named Tom. Tom could be your butler. It could be your...
Can they contest it if I name Tom?
I mean, anything could be contested, right? Anything in Trinidad could be contested.
But it does help at least to have it.
Have the person named. Yes.
It reduces the drama and the time.
The burden of proof then has to be on you to show why Tom shouldn't be the one. And that's a very high threshold to prove. Like once he's an adult or she's an adult of sound mind, what is wrong with her being the executor if the deceased chose him? Yeah, because remember, the deceased is 6 feet under now. So the judge will say, well, you have to prove to me why. Okay, you may be the deceased wife, but he obviously chose Tom to be his executor for a reason. Proof to Tom is not valid.
Okay. I tell you, Aliyah, there's so much food for thought. You know what I'm seeing here, Emily? I'm seeing a webinar coming. I'm seeing a webinar coming because there are lots of questions I know when people are watching this, questions in their head, and that we can't answer in our short show.
Exactly. I do have one really important other factor why I like wills. And so when you leave anything pursuant to death, it's called an involuntary transfer because you're dead. So you're passing, it's being passed involuntarily. Guess what? There are no taxes on involuntary transfer. So I've left a $6 million property in my will to my daughter. On death, when she gets the grant of probate, the deed that is going to convey that property out of my name into her name, 0% stamp duty.
That's very good to know.
If during my lifetime I wanted to give it to her, and I said, like, she got married, and I said, oh, let me do a deed of gift to transfer it out of my name into her name. That is a voluntary transfer because I'm still alive and I'm voluntarily giving it to her. Guess what? Stamp duty on an escalating scale based on the value of on a $6 million property. I mean, I should have calculated the figure, but that's more than $100,000 in stamp duty alone to give it to her. Whereas if she waited until I died,
yes,
gotten it tax free.
Yeah. So I think you pointed out the benefits of the way our laws are currently written to allow for tax-free transfer of assets upon death. You mentioned power of attorney, and we didn't talk about that at all. We talked about wills. please mention like why that was the first thing you actually said. So if you didn't have a will, we should at least have the power of attorney, is what you're saying?
No. So a
No.
power of attorney is only valid is only valid while you're alive. You die, the power dies,
Right.
right? And I've
The
had so
power of
many
attorney is in the event that you get incapacitated as you're getting older. Is that what it is for?
exactly, but there's a layer onto that too. It's only to do with physical incapacitation, meaning you are no longer able to drive and go to the bank, or you're migrated, you're not living in Trinidad, or you're retired and you're traveling a lot, so you're not here a lot of the times. But guess what? Now that you have online banking, you have all your investment portfolios online, you can still do that and transact on those things while you're overseas. Well, I mean, you may even be, yeah, ill as in radiation, chemotherapy, so you're laid up. But if you're physically able to do those things with your mobile phone and the technology we have now, you don't really need to give anyone a power of attorney. There are instances, of course, if you have property that's being sold or cars that are being sold, and you're not physically able to go, then yes, you absolutely would need a power of attorney then to give someone that power to sign on your behalf. But I think one of the days where to transact at a bank level that you really need to give someone a power of attorney in most instances. And I'll tell you the other reason why. So again, people come to me to do estate planning and they've read all these things online. Well, I must have a power of attorney and a medical health directive and whatnot, and they want to do the power of attorney. And I said, okay, when you finally may need this, the person that you're giving the power to, suppose you're divorced from them by then, suppose you're not your sibling and you're no longer close to them. Why do a power, which is a deed that costs you money to prepare, then costs you money to register the land register? Why do this whole power of attorney just in the event of when you actually do need it? Do it then, because then you know at that point in your life who you want to entrust with this responsibility.
Okay, so you do it when
Good
you
point.
need it. That's the point.
When,
When you
when
need it.
you
When you need it,
As and
not
when.
if you need it, because
Right.
you may not
exactly
need it.
exactly
Okay.
exactly.
Yeah.
Okay. And
Okay.
there was something else you were saying. You know, I know a lot of people, well, tend to have the practice of putting people's names on things
Right.
instead of making a will. Is that a good practice?
That's fine. Like when
Yeah.
again, when you do the estate planning consultation with your seasoned professional and you identify what you have, who you want it to go to, what age you want them to get it, these are some of the tips that they could advise you on. So if your children are all adults, you can in fact put them joint on the assets. But remember the $6
But
million
that will attract
property.
stamp duty, wouldn't it?
Exactly. Remember the $6
You
million
just said that.
property.
Yeah.
So it depends on the asset. If it's a
Right.
bank account, there's no cost. You just go into the bank and you put the
Right.
And
person's
you do that, and
on
it's
the
not a
account.
problem. Right.
But if it's
Right.
shares and property attract stamp duty. So the stamp duty for shares is less than for property, thankfully. But it means that you can't just say, okay, well, I have a brokerage account at this firm. I'm going to add my daughter on. That's not how it works. You then have to open a new brokerage account in the joint name of you and your daughter. And then
Oh,
what? But if you transfer across the shares, that you may have a portfolio, you may have some Whitco, some NFM, you may have an entire portfolio. There is stamp duty on every portfolio that you transfer across.
transfer.
Right.
Okay.
What most people do is that they leave their portfolio that they had in their sole name, and this is usually when they get married, so they now open a joint portfolio in there and their spouse's name, and as they buy and sell the new ones they buy it in the name of the joint one that's joint with them and their spouse, and then they sell down the portfolio that's
You
in there.
calculated the ones, right?
Okay.
I
Okay.
just give you a way
As
to
a way.
avoid to legally avoid stamp duty.
Right.
Yes. Oh
Yeah.
my
Because
goodness.
basically you're closing off one account by selling it down, and you're
You're
increasing the
opening,
other. Mhm.
exactly,
Yeah.
exactly.
Yeah.
You are
Okay.
dropping some golden nuggets here, Aliyah, this morning. Thank you so much. So, as we wind down, when people are listening, what would you want them to leave with? Is there any one thing that you would suggest that they do, having heard this conversation?
Yeah, I mean, as you can tell, I'm very passionate about this, right? I can speak on
Yeah.
each one of these topics for hours on end. I mean, we haven't even touched things like trusts and living wills is the same as medical directives. And again, every year around Christmas, New Year's, when you get sentimental, there are tons of memes floating around. My own parents came to me, how come you didn't tell me I needed to have a trust? And why didn't you tell me I need to have a... I'm like, Mommy, you do not believe everything you read. So the short answer to your question, Georgia, is my message is don't listen to and believe everything you see on social media, but use it. I'm glad you're seeing it. Use it as a trigger to consult an estate planning
Yeah.
expert to see which one of these you do need, which one applies to you in Trinidad, so that you can design your affairs and your assets to go where you want them to go. Out of all of those tools we spoke about, powers of attorney and wills and whatnot, the one that I would really advocate you have is a will. And I think of it as the four W's: your will, because you can determine who you want to get, what you want them to get, and when you want them to get. The other disadvantage of dying without a will and having to go through the whole letters of administration process where you need consent and whatnot, the other disadvantage to that is that when you get that grant, we spoke about your spouse getting half and all your children getting the other half. Once those children turn 18, they're entitled to it. But there may be some assets like shares in a business or some sizable funds you've worked for your whole life that you don't want an 18-year-old to get. With a will, you can stagger that. So you can say half of my unit trust portfolio to my son on turning age 25, the other half on turning age 35. You can even put stipulations. I've had people say, as long as he studies medicine, he'll be entitled to the funds in this account.
Okay.
Or when he gets married, he'll be entitled to the funds from this account. So you can be very creative.
Poor fellow, if you didn't plan to get married.
Or study medicine.
Yeah.
Right.
But the point is, there are ways you can control or manage things even beyond your passing. And sometimes, as you say, I mean, unfortunately, more and more sometimes too, you could see that some of us we pass away pretty early, much earlier than we expected. Like the example you raised, unfortunately.
Yes.
Yeah.
Yes.
Yeah.
Wow.
Yeah.
Thank you, Aliyah.
Yeah.
Well, Emily, over
Sobering,
to you
right?
to wrap. Yes.
This is a sobering topic for a Monday morning. However, it's really important that you think about becoming the CEO of your legacy. You do not have to have billions or millions or, in the bank to do it. The point is, you have a legacy. You work for something. They are assets. You have people you love or causes that you really want to support. Um, and think about what Aliyah said in terms of getting a will done. Don't be like the 42 people who did not take up the request. It probably isn't as expensive as you think to at least have a consultation, and just make sure that the consultation you do is with a proper person authorized to do so in Trinidad and Tobago, because
Yeah.
that is the law under which we exist.
That
So
was a
those are the three
perfect
things.
summary. A perfect summary. And you said you made a point that I didn't even elaborate on, which is that again, in your will, you can leave things to charities, to your churches, your mosques, your temples, big causes, your TTSPCA, cause you're passionate about. When you die without a will, it's spouse and children. If there are no spouse and children, it goes all to your parents. And if you didn't have spouse, children, or parents, it goes to your siblings and then your half siblings, then your grandparents, then your nieces and nephews, then your uncles and aunts. And then if none of those people exist, it goes to the government of Trinidad and Tobago. You
Look at
could
that.
control that. You could control that in your will. I may want to leave things to my aunts. They took care of me, picked me up from high school. But look where they are in the pecking order of the law of Trinidad and Tobago.
Exactly.
So don't leave it to chance.
To chance.
Control.
Yes.
Thank
If
you.
they hear nothing else, Emily and Aliyah, don't leave it to chance.
Yes.
Yes.
Thank you. This has
Perfect.
been so good.
Very
Aliyah.
welcome. Thank you for inviting me. I'm very passionate about this. Would be happy to talk to anyone about how they can not leave it to chance.
Great.
Yes.
And we will
Thank you
leave your
very much.
contact information on our platforms, and also you can connect with Aliyah and Exec
Executive.
Trust.
Yes.
Exec Trust. Why did I always want to say something else? Exec Trust
Yes.
on LinkedIn, and you can look them up. I think you all have a website too, right, Aliyah?
Yes.
Exactly.
www
So we'll
Executive
leave
Trust.
all the links. Good. We'll leave all the links
Very
so you
good.
can check it out. Thank you again. Take care.
Take care. Bye, everybody.
Bye.
Bye.